Hello everyone. Welcome to our Women in Sectional Title webinar. We're back again for another month discussing insights into South African sectional title property trends. Another warm welcome to our very new sponsor on board. I'm very excited. Thank you so much, Aubrey Snyman and Jenny Allison, for coming on board. Property Intelligence has joined us as a sponsor, and we are really exceptionally grateful for the support. Our other sponsors are Zfin, Sectional Title Solutions, We Connect You, PKF Octagon. Without their support, we really wouldn't be able to carry on. So we are appreciative of that, and onwards and upwards. There's so much to discuss. Hello, Lillian Waldeck, and I saw Aubrey Snyman's also on board. We've got quite a few things to discuss today. What I really wanted to start off by saying is for the last 2 weeks, I've been in the Western Cape, going from managing agent client to managing agent client. We've had about visited 12 offices over 3 days, and it's been insightful for me. And I thought maybe perhaps before I start speaking about my predictions for 2024, we can discuss a couple of things that managing agents have said and have told me. And it's almost like it's the same type of issues and the same kind of things coming out. So let's talk about them. So firstly, I'm feeling that our managing agent portfolio managers are pretty overworked. I won't say underpaid, just overworked. They've taken on a lot of new administration tasks. And I think that can be really daunting, particularly when you've been, pushed to gain critical mass in a medium-sized managing agency, and you're pushed to deal with all these buildings. So there is a lot of extra work. Some of that extra work involves frustrating things like the PPRA, Property Practitioners Regulatory Authority. And I know that a lot of you who are actually sectional title portfolio managers are understanding where we're coming from on that. And what I'd like to say to you is, if you are experiencing the issues with the PPRA, please send your queries to us. Let's see if we can somehow intervene. Let's see if we can get involved. The other thing is We Connect You for the CSOS. Also, many of my clients have been experiencing problems in duplication of buildings, and certainly sometimes where there hasn't been payment made, and buildings haven't been registered where they were registered in the beginning. So those are the issues that we're dealing with. Let us know, because we can also escalate it to the CSOS. One of my clients here in Johannesburg had the CSOS actually visit their offices to go through all their queries and to get things done correctly. So please don't hesitate. Reach out. Let's see where women in sectional title can also get involved to escalate those kind of matters. Something else that really came up, and I think the legislators are loath to changes. I'm not sure what the mentality or rationale is, where you need to get a quorum and you can't get a quorum. So quorum requirements are proving really difficult to get to for our portfolio managers. And portfolio managers, as a matter of course, are just postponing for a week, just making a booking, even without knowing that there's going to be a postponement, because it's just rife. And I think that's something that as a community, we need to approach the CSOS and take it on board, because the situation is not getting better, and it's costing managing agents time, it's costing frustration, and it's creating backlogs with things that need to be done. So that's something at top of mind. Interestingly enough, with all the managing agents across the Cape, well, the areas, this northern suburbs, southern suburbs, Atlantic seaboard, protection orders in complexes are increasing. So that's when you have domestic abuse, violence, either against the trustees or between owners. That's something that has definitely come up. And I think that protection orders, you can approach the court for a protection order. You don't have to make any payments. And I think certainly that is something perhaps that we need to look at for our Women in Sectional Title webinars going forward. How do you get a protection order? What are the things that you can do? Can you approach the trustees or the chairperson in the event that there is assault going on? So I suppose it's almost like a sign of the times, where we're sitting, with people who are aggressive, who are showing their aggression in this way. So, yeah. I'll come back to my Cape Town trip when we've gone through my 10 predictions for the year. And of course, nobody has got a crystal ball. But at the end of the day, I think working in this space gives me the unique opportunity to evaluate, sitting from the outside, looking in, and obviously going on different road shows, speaking to managing agents, and being in the space where we're representing not only owners, but also trustees. We represent developers very often, and even the occasional estate agent. So, let's see what after a year we can come back to this table and see. And please feel free to put your questions into the chat box as well. I think that would be great so that I can have a look and see. I see Jenny Allison says, thank you. So happy to be a part of WiST. Yeah, we appreciate you guys. Thank you very, very much, everybody. Okay. All right. So let me start with my predictions, and then we'll end off this webinar going into a couple of things that I discussed as well with my managing agent clients in Cape Town. So the first prediction is that far fewer owners, you can have a pen and your notebook, far fewer owners are going to want to get involved in becoming trustees. Okay, so a lot of you are probably nodding and saying, yeah, we owners don't really want to get involved with the argy-bargy of being in the sectional title space. It's a difficult space to get involved with, especially when there's no training. I think if it were compulsory to make the training within 60 days or 90 days after becoming a trustee, I think you'd probably get even more people who might run away from the position rather than toward it. But maybe you'd get more worthwhile people becoming trustees. So what is the situation when you've got a building and trustees are holding up their hands and saying, I don't know. One of my managing agents in Cape Town actually mentioned to me of a very large building, prestigious building in Greenpoint, said to me, I just cannot get instructions from the trustees. They just don't want to get involved. This one's always overseas. That one never wants to take responsibility. Well, let's look at two situations where we've got sort of trustees who are AWOL. The first thing is that you can place a building under administration. So any owner or creditor of the body corporate can place the building under administration. But what does that mean? That means that the administrator will walk in and basically sideline the trustees completely. So there won't be any involvement with the trustees. It's like they're saying, I'm in charge. I don't want to hear anything more. I'm going to deal with this. And in 6 months' time, I will put together a report and take it back to court and see what's happening with the building. That's the one way of dealing with it. The second way of dealing with it is for the appointment of an executive managing agent. And when I spoke to a couple of the sponsors about predictions for the future, Michael Schaefer from Zedfin was one guy who put up his hand and said, certainly there is an emphasis on executive managing agents and the appointment of executive managing agents. A few of my Cape Town clients didn't actually understand the appointment of executive managing agents, and we're almost too scared to touch it, where I feel in Johannesburg, there's been a lot more traction. So let's just go through this executive managing agent concept again briefly for you. An executive managing agent can be appointed by a bondholder or by a special resolution of the body corporate. Or if the trustees all decide to agree and they've got no pushback from owners, then an executive manager should be able to be appointed. The executive managing agent will work alongside trustees if necessary. My opinion is that this executive managing agent has almost taken over the role of the trustees, but it's not ousting trustees, like placing somebody under administration. It's about working side by side with trustees, but being in a position to really executive manage. take decisions, roll with things without getting the other trustees too involved. The problem with the executive managing agent that we've seen currently is that they are liable in the same way as trustees are liable. And how a trustee is liable? Well, if a trustee breaches his or her fiduciary duty, that trustee can be held personally liable for the consequences of that breach. At the moment, so can an executive managing agent. And that's why so many managing agents have said, no, thank you. But the good news is that when new amendments come in about a year or 2 years, the Ombuds Service is definitely looking at amending the legislation to say that will be an indemnity for executive managing agents. Executive managing agents definitely have a role to play, and I think that they are being recognized as a force in the industry. If you look at the amendments for going forward, in terms of the new amendments for the 2 years, wherever it says managing agent, wherever reference is made to managing agent, it also says / executive and or executive managing agent. So it's something really worthwhile for managing agents to consider. I have a worry and a concern about executive managing agents appointed to the CSOS panel of executive managing agents. I'm not 100% sure that the executive managing agents on that panel have the knowledge or expertise to be dealing with subjects and with the enormity of being an executive managing agent, because it's almost like you even more in power as an executive managing agent is. I also received a message from one of the appointed people on this panel to say that they've approached an auditing company to see if the auditing company could help them because they're new in this industry and they don't have any knowledge about accounts for sectional title. I mean, that's someone who's currently on the executive managing agent panel at CSOS. So that is of grave concern. And I think that CSOS need to be a little bit worried about that. More and more you're finding with the socio-economic position we're in, we need audits, we need auditors, we need people to be able to hold bodies corporate accountable. You have trustees who are dipping their fingers into trust accounts, who need money to tide them over for the month or to, maybe to pay their own levy somewhere. I'm not sure, but we're seeing more of it. So we have to have a tighter grip on money, particularly in the executive managing agency space. So I'm not sure what your experience is of an executive managing agent, or if you have any questions about that, but yeah, please feel free to ask. On our videos page, we also have an interview that was done with Michael Schaefer at ZFIN. It was quite a while ago, but we actually unpack the role of the executive managing agent. So you might want to go back and have a look at that on our website, www.womeninsectionaltitle.co.za. Also, there are over 40 webinars on the events page. If you're new to this group, please go and have a look. We've recorded all of them, so you can also watch these webinars in your own time. The second prediction is that we need to see more women in senior roles in management, and I think we're going to. A prediction of mine is that we will see more women in sectional title roles, in management roles. I think that's going to really play a big part. And not just, portfolio managers we've seen over the last couple of years, there's been a definite increase in the role of portfolio managers as women. And really going around and seeing my clients, around the table, there are definitely more women than men. And I think the older chaps in our industry are maybe going into retirement. Those are the guys who headed out things going into retirement. Although you'll laugh, because at one of my managing agents in Cape Town, it was quite funny. I went to go and talk to them, and one older chap who was sort of in retirement age, he had never met me before, and he said, is that Maria lady still around? Has she retired yet? So I just want to let you know, I've still got another good 10 years, right? No retirement for me. But certainly I would like to see in these next 10 years, or even in the next year, I want to see more of you ladies in positions of strength within your managing agency team. And perhaps it's time to do a bit of reflection and to say, right, where am I going in my career? Maybe I can do some business courses while I know you don't have time. I know time is an issue, but also some things just to upskill everybody, to have a look at that. Just a question there. Kath Kate says, should one call for a forensic audit? Tick the box. Well, I don't think a forensic audit is necessary unless there's reasonable doubt or concern, Kath, that there's something to worry about. Usually your auditors would have a feel for what's going on, and certainly if there's a qualified report on that. I mean, guys like PK of Octagon have also mentioned to me that they are doing quite a few forensic reports. They are also, in addition, doing the books for a lot of estates. So anyone who's looking for specialized auditors for big estates, you speak to Alistair Scholz from PK of Octagon. But at this stage, I think that forensic audits, I mean, they're expensive. Forensic audits are expensive, so it depends on the circumstances. Absolutely. There are new amendments. The third prediction is that there will be new amendments, and my prediction is that they will come in the next 18 months to 2 years. I think that you're looking at things like 20 Rand across the board for CSOS levies, so it won't be capped at 40 Rand anymore. They're going to bring that down across the board. So it won't matter how much your levy is. You won't have to do that little calculation. It will be across the board. We're looking at much higher onus placed on the body corporate to make sure that extensions are regularized. So those extensions where you get a special resolution, but then at the end of the day, the owner who's obtained the special resolution and who wants to extend just says, well, I've got everything now that I need. They don't appoint a land surveyor, and they don't pay a higher PQ. That is definitely, my prediction is going to be that that will change, and that will be an amendment to say within a certain time period, if you haven't appointed a land surveyor, or if you haven't upped that PQ from date of special resolution, the body corporate will be given that responsibility, certainly, to do so. That's definitely something that's coming in. Also, we predict that amendment will be made with regard to the trustees. If you're a trustee, you should not be able to be in arrears with your levies. You should automatically lose your trusteeship and your custodianship over monies, because you're not very likely to hand over debtors if you're a debtor yourself. So that should come in. And again, it will be if you have been convicted by the, you haven't paid, you've got a judgment from the courts or an adjudication award from CSOS, you won't be allowed to be a trustee. I foresee that coming. Obviously, that's not the situation now, and it's a major, major problem. I think other changes will revolve around the panels for administration. So administrators may not be court appointed. Remember, to refresh your memory, they used to be High Court appointed, then they became Magistrates Court appointed now, and then I think we're going to move to the CSOS board, actually appointing administrators. Again, opening the way for possibly not such qualified administrators. It's a concern. We've got to have our eye on that. And I think that's the bottom line. We've got to watch over our industry. We've got to see to it the things we like or don't like are expressed. Never be scared to write to the Ombud to say we don't feel that this is good, or write to me, or write to the whoever you feel has got a voice in the industry. We can certainly take it further. So those are just a couple of the new amendments, but there will be legislation. There will be many more directives from the Community Scheme Ombud Service, and I think these directives are pretty powerful. Let's hope that they carry the weight going forward that they deserve. Our fourth amendment, or prediction, I think structural building defects will be on the rise. And I'm seeing that in our industry a lot in a lot of the buildings. And that's due to poor workmanship. You know, during COVID, things were done in a little bit of a slapdash manner. You've got people developers who wanting to finish their work and build in winter and try and get things done quickly. And I'm shocked. Every time I drive around Johannesburg, and certainly now when I was in Cape Town, about the number of sectional title units that have just gone up so quickly, very, very quickly. And it begs the question, have shortcuts been taken? What is the situation regarding the maintenance, repair and replacement plan? Certain buildings in the Western Cape don't even have a maintenance, repair and replacement plan. That's, that's just absolutely 100% unacceptable. Lack of money and finances goes very much towards the situation where there's no maintenance. And this is why bodies corporate need to prioritize with regard to their maintenance. They can't do everything possibly, but what needs to be done first? What's the top of mind to be done first? Planning sessions, strategies, all of these type of things, I think, need to be taken into consideration. Sandy says, can you touch on Splumer Act in terms of new complexes going up? Yeah, that's the spatial planning legislation that Sandy's talking about. I think that, I think the new complexes do have to take into account all sorts of things with regard to the spatial planning act, and that is based on the FAR, the floor area ratio. It's got to do with the mix of residential and office space. It's got to do with the impact, a lot of traffic assessments and impact studies. And I think that zoning is going to become a very big part of that as well. And zoning will also play a role in terms of the Splumer Act with regard to Airbnbs. And Airbnbs are now with the tourism board. And I was chatting to a couple of key people in the Cape Town spheres of government asking about this amendment bill to the Tourism Act, which seeks to clarify exactly where in Cape Town you're allowed to Airbnb, because at the moment, there are more Airbnbs per square kilometre in Cape Town's on the Atlantic seaboard and certain other spaces, West Coast also, than anywhere in any city in the world. So there's going to be some hard work being put into all these type of things to address them. And at the end of the day, we are subject not only to the Sectional Titles Act when developers put up things, but also in terms of these type of acts as well. Something we did touch on last month with the New South Wales legislation, in terms of one of their new acts, Construction Act, they have to have electric vehicle charges for every parking bay that goes up now as well. So again, you can't just read the Sectional Titles Act and zoning bylaws in isolation. All these other acts have to come in. Also, impact on environmental impact, hugely important with Splumer. In terms of where things go up, is it a wetland? Is it a space that has been reserved for a conservancy? Environmental issues are the order of the day at the moment, as they should be, I think. And Cape Town certainly are much more aware and more alive to environmental issues than we currently are. That's a feeling that I've received. Let's go on to the next one, and that's about climate change as well, impacting on extreme weather events. And I've put that under my fifth prediction, which is sectional title insurance crisis. Sectional title insurance is at the moment going through crises, in that I'm getting guys like Mike Addison from ADSHRA phoning me and saying, I'm getting very concerned because we're getting 30-day notices from insurance companies terminating their agreement with our buildings. That's huge. I mean, we've never seen that before to the extent that we're seeing it now. And why are they terminating their agreements with the buildings? Because of lack of maintenance. They're saying we're not prepared to insure this building due to the lack of maintenance in this building. And I mean, that is very big. Or they're saying we're putting a suspension on this building for a period of 3 months, and you've got to come back and show us that your maintenance has been undertaken or effective. And I think that's going to play a role again. Fiduciary duties of trustees. What are trustees doing? Because if a building is not insured, that affects a trustee. And I can sue a trustee personally if there's no insurance in that building. So that I really believe we must look at. Let's look at and see what we can do about it. And from the insurance side, climate change impacts as well on extreme weather conditions. So if I can just talk you through a couple of research recommendations that were carried out in Singapore, climate change research recommendations. And seriously, Singapore is a place that knows their stuff on environment, and certainly mostly about water and water conservation in our schemes. What they've said, building standards should meet heightened standards with respect to climatic event resilience. So are our buildings resilient? And in a visit that I took to Dubai a number of years ago, Dubai were starting to put these things into place because of the desert. The desert has huge implications from a soil erosion point of view into buildings and rust and all sorts of things. So they were already aware of that. Developers should be provided with information and kits about climate change and adaptations to make buildings, again, climatic resilient. So that seems to be the buzzword, climatic resilient. What kind of things do they need to do? Well, you know, they also need to put in place emergency evacuation and management plans. That would be for the portfolio managers, and any developers going into a building would have to have that as like their starting pack. Transparent insurance weather assessments. And I'd love to speak to Mike, possibly Mike Addison, about this topic. What is being done at the moment in terms of sectional title, insurance, and weather? Include projected spending in budgets. That's something that's certainly being predicted. Something I also need to say to you, and it's not just because I'm a lawyer, but legal expenses should also be put into budgets. We're seeing a lot more of that, so that, you know, you don't have to raise levies and special things to pay if you're going, you know, if you need attorneys and that type of thing. Legal expenses and budget for climate expenditure. Also, provide training manuals on climatic change. What is happening? When do we expect things? How do we see things happening or playing out? And interestingly, they're saying in Singapore that banks should be providing a rating system in giving bonds on climate change buildings. So if your building is not up to speed with its climate change, you know, where are we with that? How does a bank actually give out bonds? Are they less likely to prefer certain complexes? And when I talk climate change, it's about hot weather, it's about exceptionally cold weather, it's about dry weather, and it's about wet weather. These are all the type of things that we're experiencing with climate change. So that is certainly taking things onto a different level. Then number 6, we're on number 6. So let's just go through it. Number 1, far few owners wanting to take on trustees roles. Number 2, and the rise of the executive managing agent. Number 2, more women in senior roles in management. Number 3, new amendments across the board, across Sectional Titles, Management Act, as well as the Community Scheme Ombuds Service Act coming in 2 years. Number 4, structural building defects will continue to worsen, and because of lack of money and lack of maintenance. Number 5, sectional title insurance crisis, 30-day notices and climate change impact. Then number 6, more pets, I predict, in sectional title, which is a happy thing for me, I think. I think there should be more pets in sectional title buildings. I can see my portfolio managers sitting there shaking their heads. I know it's a headache. I understand that. But if you look at countries all over Europe, there are pets in sectional title apartment buildings. If you go to France, Paris, if you go to London, there are more pets. And certainly if we follow the New South Wales legislation and also have a look at our Community Scheme Ombuds Service orders at the moment, there seems to be this tendency towards prohibiting the pets, banning pets rule. So they don't like seeing an all-encompassing rule saying no pets allowed. I mean, there's still a debate about that, and there's, I'm not 100% sure that the Ombud can make the order that you can complete, you can prohibit the banning. Maybe some complex wants to say no pets allowed. But again, you just start seeing these trends. Also, you see with the Community Scheme Ombud Service, they don't like discrimination amongst pet owners. So if you do place a prohibition on the banning of dogs, you can't place a prohibition on the banning of cats. We've seen that. Something else that I've also seen is if you have this double-story building and you have the lower ground floor levels with a garden, but the upstairs doesn't have a garden. CSOS Awards have said you can have pets only in the garden units. You can't have pets above. And that the CSOS didn't agree with, and said if you have dogs at the bottom, or cats and cats, and you must have dogs and cats at the top as well. So it's this, everything is starting to push towards not only owners being allowed pets, but tenants also being allowed pets. There was a difference in the New South Wales about that, whereas in South Africa, it doesn't matter if you're an owner or a tenant, the pet rules will apply to you. So tell me, let me know in the chat box, do you like that? Don't you like that? I think if your conduct rules are good, then you are definitely going to gain traction from having well-behaved pets and happy owners. Conduct rules are very, very important in sectional title. And might I just take a moment now just to mention to you, Women in Sectional Title, this platform, we have put together a really fantastic set of rules, which I've had really a lot of input into after having 26 years of experience. It's a template set of rules, and you can amend those rules. Just ask if you need us to send you those rules, please let us know. There's a 2,500 Rand fee for that set of rules, and you can make whatever amendments your body corporate likes. And I think it helps a lot, because then your body corporate your trustees can go through the rules at their own time and work out what they need, what they don't need. In other words, there's every eventuality in this set of rules. Please let me know if you're interested. It's marina@bbmlaw.co.za. And I think that really is going to help a lot, because bodies corporate seem to have a problem in getting their rules up to speed. Kath says owners should be able to have pets as long as they not constitute a nuisance. The owners, that is. Yeah, 100%, Kath. I absolutely resonate with you when you talk about troublesome owners. And again, that's why, things like protection orders are gaining ground in our sectional title complexes. And I think that trustees need to be robust in dealing with troublesome owners. If you let troublesome owners step all over you, you're going to have a problem. That is my experience in these complexes. We've had 2 cases in the last 4 months of owners that we've had to place under administration by family members, because they basically cannot sort of take care of themselves or cannot take care of their own finances. They require help, or they need to go into some sort of home. We've had 2 of those. So that would mean getting a curator to take over the affairs of that owner and putting up the unit for sale, things like that. Then there are some people who don't need to go into a home, but it caused trouble anyway. More noise, nuisance, that type of thing. My prediction is that will never end. That will never end. Difficult owners, difficult problems will never end. So I think everybody also knows that. Then let's look at number 7. Number 7, what's going to happen with managing agencies? And this might be interesting for managing agents. I think that larger buildings, larger business managing agents will start swallowing up the smaller, medium managing agencies. Middle tier managing agencies are going to have greater challenges in the coming year or years. I've always been aware that managing agencies battle with very low margins. That's why they've always wanted to charge different things, different fees for different things. And now they've even been curtailed by the Debt Collectors Act, for example. You're taken on by the PPRA if there are any extra additional charges, and yet there's so much more work. So your middle tier managing agents are not reaching critical mass. Your large managing agencies are going to come up and buy those middle tier managing agencies. That's number one. Number two, your very small, or the guys who've been in large managing agencies who don't like that kind of corporate environment will definitely fall off and will start maybe their own very small managing agencies. So the middle tier managing agents will have a problem because they don't have the resources that the large managing agencies do have. The finances will be an issue, and they also don't have the time and the service offering that maybe the very small guys, if you've only got a couple of buildings, you can really, you can visit the place, you can go to the people, you can offer a better service if you don't have so many buildings. So that is something that I think is going to happen. I've already also, again, always received queries from larger managing agents when they want to buy the middle tier managing agencies out. And I've seen quite a few of those deals going through, if not in the city centres, in the more urban sort of districts, I've seen that happen. We'll see more of that, definitely. I don't think it's necessarily a good thing, by the way, because I think to innovate, your big managing agents will have the market share, and it might slow down innovation and that competitive kind of nature of our business. All right, number 8. I think something that we all know a lot about, that is that arrear levies are going to get worse. Yeah, arrear levies are going to get worse. Already in our business, when I say our business, as an attorney, I see arrear levies creeping up in many of the big buildings to dizzying heights. There's some matters we're dealing with where we've got over 500,000 Rand worth of arrear levies in one unit. And I mean, that is across the board a real problem. What I want to alert you guys to is that we are quite successful at BBM attorneys, and I know attorneys across the board are doing disconnection applications. So in the disconnection application space, you're asking for 2 things: disconnection of electricity. The one prayer is for a disconnection application. In the same document, you're asking for payment of the arrear levies, and you're taking this now through the High Court, which is more efficient. It seems to be more efficient. And you're not stuck with the limit of the High Court. You're basically going to disconnect. That's how you're getting into the High Court. We've done that for the past, say, 3 years or so, and we've gotten our disconnection applications. Then the Lionsgate case came in, body corporate, Lionsgate body corporate. There was a problem where the court said, you can get your payment order, number 2, but you can't get your disconnection application order because it has to be in the rules that the body corporate or the trustees is given the permission to approach the court to disconnect. Well, we disagree, and we are taking this matter on to appeal. We've got leave to appeal from the High Court, and you'll be watching the space for more news on that, because we don't agree with that. You shouldn't have to have it in your rules. If you are changing your rules at this stage of your schemes, I think it's a good thing to put it in, by the way. So you put in a clause to say that the body corporate provides the trustees permission to approach the High Court for disconnection of electricity order in case of arrear levies. I don't think it will hurt. I think it's a good thing to do that anyway. So for arrear levies, even developers here in Joburg who are having huge, that holding many units in buildings where the developer has developed hundreds of thousands of units. I won't mention the name of the developer, but they have to relook at the entire budget with regard to holding costs because arrear levies are just starting to go through the roof. So we've got to look at other ways. How do you collect levies? We know you can go through the thesis lots of complaints going through the CSOS. And if you can't get an order, you've got to go through the High Court in any case. If the court process, always constant battle to push forward and get anywhere there. But I mean, that's the way that's working at the moment. So we need to look at other options on that. Okay, so real levies will definitely be, getting worse. And I think number 9, cash flow issues for your buildings are going to tighten. Cash flow is going to be a problem because you have to increase levies because contractors are increasing their prices. Inflation is going up. I mean, there's no doubt. Your insurance premiums are definitely going to increase, particularly where insurance companies are getting a little bit twitchy about insuring a building. There's a pressure to maintain. And managing agents, certainly, in my view, need to be putting up their fees. Again, during the talks with our managing agents, the problem is that the fees are not high enough. Your fees are not high enough. We talk about professionalizing the industry at the NAMA seminars, at the NAMA convention, held every couple of years. We're talking about professionalizing, but the only way is to release this fear of actually putting those fees up due to competition and due to undermining, other managing agents coming in and undercutting. I know it's a problem, and the thing is, it takes guts to know your value and to increase your fees based on your value. But certainly, I think there will be cash flows for issues. Don't let your managing agency fee be the first one that you cut out and just say, okay, well, I know you've got cash flow, but I'm happy to help you. I'll reduce our management fees. No, very bad idea. There's got to be other ways of assisting bodies corporate, but your managing fee certainly should not be one of those ways. Okay, then the last one, number 10. My prediction is that the volume of communication in schemes is going to get out of hand. And I think that's something where you certainly as portfolio managers can take that and nip that in the bud. I mean, it's all this instant gratification. You send a WhatsApp message, an owner sends you a WhatsApp message, and 10 minutes later, they're putting little question marks about, why haven't you responded? Or what's happening with your response? What is happening? I mean, that's firstly terribly rude, and secondly, really not on. So owners also, on the other hand, don't want to share information. So your trustees don't want to share information. You're getting this pushback of the puppy and what information you can send back. I was actually in an interesting meeting now for one of the buildings in Sea Point, where the trustees received a letter from an owner saying she wanted all the details for the owner. And the trustees said, no, what do you want the details? Quite a troublemaker owner. What do you want the details for? And she said, I want to send everybody a message about Airbnb and what I'm doing and why I think Airbnb is a good idea so we can change the vote at the next AGM on Airbnbs. And the trustee said, no, legitimate, you need to have a good reason. We need to have a good reason for giving out owners details, and that is not a good reason. So they took it to the Ombud. The Cape Town Ombud disagreed with the trustees. It just came out now, the ruling, and said that the owner did have legitimate cause to request the names and details from the managing agents. And that's section 31N, I think it is, of the Sectional Title Schemes Management Act, says that the body corporate can give over the information if it's for a good cause. And the Ombud held that, yes, this is for a good cause. She wants to alert other people to something that's operationally within the mandate of the owners to be given that. I think the one problem, though, for the Ombud there is that about 15 of the owners out of the 18 of the owners didn't want the trustees to give this particular woman the details. So the Ombud seemed to have missed that point. But anyway, so I think we've got things like rude bullying behavior by owners to managing agents. So, you've got all this type of free flow of information. And I really believe that these portals have assisted. Things like We Connect You, who've really acquired a very, very good name as well in the software development, have made a name for themselves. By the way, just one last thing before we finalize. Jenny Allison at Multiprof said one of her predictions was for software development to include storage of things like documents, sectional title plans, all that kind of thing. I'm sorry, I nearly forgot to tell you about that. Thanks for that, Jenny. But I also think that software developers need to take into account communication skills, the soft communication skills in terms of inter sort of party communication between trustees and managing agents, but not only that, owners and trustees, and owners and managing agents, so that we can buffer the poor managing agent against this onslaught of communication and make communication more valuable. For me, communication is absolutely number one skill that needs to be improved. And my prediction is that it's getting it out of hand if you don't take it in hand. So I think, yeah, look, those are my predictions. Again, we don't have a crystal ball. We don't know what the future holds, but certainly we'll come back in a year after this and see if those predictions have been proven to be correct. Thank you again to each one of you. We appreciate your support and keep watching the space. Don't forget about the template rules. If you require a copy, please email me, marina@bbmlaw.co.za. Thank you very much, everybody, and we'll see you next time.